Hi, everyone. Harry here to talk about the Supreme Court's dissolution of a stay entered by a district court in Washington state, telling the administration you may not put your ban on transgender service in the military into effect. All right, let me start with the district court opinion. Really very emphatic. And it also was driven in part by Ninth Circuit law, which is itself emphatic, saying that discrimination against transgender people on the basis of their transgender identity is discrimination on the basis of sex. That matters because discrimination on the basis of sex is a pre-existing category that the courts have ruled requires a added intermediate scrutiny, as it's not scrutinized as rigorously as, say, a flat-out ban on speech or racial discrimination, but it's not the easiest either. It's a middle level where there has to be a pretty good fit between what you're doing and why you are doing it. And in this case, there's like no fit. So just to review the history a little bit, over the last 4 years of the Biden administration, transgender people were serving in the military without issue. A lot of evidence they bring to the table as plaintiffs in the case after Trump and Hegseth changed the policy that, like, there's no problem here. There's no morale problem. There's no anything problem. They're serving honorably in barracks with people of their now chosen sexual identity. And that's sort of, for starters, that this just doesn't really fit, but it gets worse, I would say, for the government, because what the judge in Washington state is able to show is the administration hasn't given any reason, and it really hasn't. So Trump it gave one reason when the ban was imposed, and it is a really, nasty and tawdry reason. It's that transgender people are sort of living a dishonest double life, not accepting their sexual identity at birth, and that is antithetical to the military's purpose of uprightness and honesty. That's seriously what's in the Trump executive order. It's just foul, right there, to characterize transgender people that way. And that's about all there is. And when they then came to court in the district court and tried to make other arguments, the judge was able to say, I see nothing here. There's no findings. There's no evaluation. There is nothing. All right. And that brought us to the law, because, as I said, the law gives a pretty rigorous standard, intermediate, but that's usually enough to defeat sex-based stereotypes for discrimination based on sex. And the Ninth Circuit has made clear, that's the circuit above this judge, that applies to transgender status. And the Supreme Court has pretty well made the same thing clear. In a case called Bostock a couple years ago, you may remember, Justice Gorsuch held that discrimination on the basis of sexual orientation or transgender, it's right there in the opinion, is in fact sexual discrimination based on sex within the meaning of Title VII. Now, that's a statute, the General Civil Rights Act, and so it's theoretically possible. You can imagine saying, but we interpret the Equal Protection Clause of the Constitution differently. But man, it's very hard to see. So the setting for the district court order is not just the Ninth Circuit, but the Supreme Court has said transgender discrimination on the basis of transgender identity it's discrimination on the basis of sex. It's part and parcel. It's of the category. Okay. So the district court, after finding you guys have nothing, you've made it up, there's no basis. And then in addition, goes through a whole series of, by the way, this violates the Equal Protection Clause of the Fifth Amendment. By the way, it violates the First Amendment. By the way, it violates equitable estoppel. These guys came into the Army to give their service to the country, and you can't tell them now that they weren't allowed to, et cetera. So, it is a pretty emphatic and you could say like patriotic opinion, a little bit as I was saying in the other YouTube about the AEA. Fundamental justice is at stake. And I gotta say, we fought these wars a little bit with sexual orientation in the Army and don't ask, don't tell. But you could at least imagine the argument there of, service in the same barracks as homosexuals who are sexually attracted to their bunkmates and the like. It's never fluent, and gays and lesbians have served with great honor in the Army. But here, transgender status. What is the big deal with it's very hard to even come up with a problem for that someone of transgender status is serving in the military, and it seems quite clear that it's just, as the plaintiff said, the order drips with contempt for transgender people. It's part and parcel. Remember, this was the #1 campaign commercial that Kamala Harris, oh my God, supports bathrooms of your transgendered identity or whatever. There's just something really visceral there. Okay. Now, so on this basis, the district court enters a stay, and so it's not going to go while the whole thing is determined. It's not going to be in effect. And at that point, the case goes to the Ninth Circuit, and the Ninth Circuit, reviewing an emergency application again from the administration, says, we're not going to change that. The stay remains in place from the district court. Yesterday, the Supreme Court dissolved the stay. There were at least 3 dissents, 3 noted dissents by Kagan, Sotomayor, and Jackson. But the order overall is perfectly Delphic. It just dissolves it and says, until such time as the Ninth Circuit decides the case and it comes to us on cert, and we either take it or not. But for now, the ban is off, meaning number 1 practical headline, they can put the policy into effect today. And that means I think it's actually would be dishonorable discharges, but in any event, discharge transgender service members from the military. And just stop and think about that for a moment. This is one of those orders from Trump that is, heads I win, tails you lose, because the people now are being kicked out of the Army. Maybe in a couple years, it's shown to have been a constitutional violation, but they've had to get on with their lives. They've been denied the opportunity at this juncture of life, which is when, young people tend to take it, of serving the Army. The blow, even if it turns out to have been unconstitutional, still lands, and in a really serious way. And that's because the Supreme Court has said the stay is dissolved from the district court, and this can go into effect. Okay. Why did they do it? We have the Bostock case that seems to say, for a majority of the Supreme Court, this is discrimination. What is going on? And this is on an emergency footing, remember, so it's all the special showing of who's likely to succeed and is the injury irreparable. And, the administration tries to argue, yes, it's irreparable this minute, even though there's been service for the last 4 years without real incident. But the #1 argument that the administration keeps making that could be what the majority of the Supreme Court had in mind, it's the military. Judges, keep your hands off the military. So there's general law out there that does say that you get an extra measure of deference. It's very similar to the kind of trick or finesse that the administration's trying to play in other settings, saying things like we have to ban or punish these law firms for national security reasons. Give me a break. Everyone knows it's a lie, but they think they can proffer it and make the courts stand down. That's what they've done here. And if I had to take a guess, as I've mentioned, it's up on, procedural kind of complicated ruling and the emergency footing and that 4-part test, et cetera. But what caused 5 members of the Supreme Court to dissolve the stay seems to me that's the factor that's out there. And if that is the factor, then what they presumably would have been analyzing is, hey, there's no likelihood of success here by the plaintiffs, even though the constitutional law of equal protection normally would be with them. That changes in a military setting. So all that now, it's a chain of suppositions, right? But it just seems to me more tenable than any other that's lurking in the case. So there may well be 5 members of the court who stand ready to say, yes, discrimination on the basis of transgender is discrimination on the basis of sex, but the military can do it, or at least we can't second guess them. Huge problem, though. As I mentioned, the constitutional bar on discrimination on the basis of transgender status is part and parcel of the constitutional bar on the discrimination on the basis of sex. So this would, it seems to me, imply that you can also actually just tell women they can't serve or discriminate on the basis of sex within the military in one fashion or another, and the military could just say we don't have to justify it, and the courts would have to have their hands off as well. Almost incredible to try to imagine the court countenancing anything like that. Now, the quick riposte would be, yeah, but they're not really going to do it. But that's not how it works in the Supreme Court. If they have a ruling that basically would green light in practice a ban based on or discrimination based on sex in the military, that's something whose the unconstitutionality, which is very well established. Okay, so on the one hand, the fact is, the important thing, the stay has been removed and the ban can go into effect immediately. And that means that win or lose down the line, transgender service members are really, really screwed, and it's just a rank injustice. Now, what does it portend for the future? Again, through a glass darkly, as I think that's a Rolling Stones album, but trying to figure it out. The best guess, I'm not, betting dollars to donuts on this, but the best guess is 5 members of the Supreme Court are ready to say we can't second guess the executive in military matters like this. But then if that's where they're looking at, what the hell are they going to say about, could the military just discriminate on the basis of sex? Now, that kind of reasoning may well be what, you have Kagan, Sotomayor, and Jackson already dissenting. So whatever is in mind for the court, they don't agree with, and it breaks down along traditional lines in the court. We'll see. It wouldn't actually come to fruition in an opinion until next term. But there's the real portent of a nasty ruling that moreover plays into Trump's overall strategy of trying to make the courts give him free rein on the asserted basis that this is special executive powers that the courts can't question. So it left me a little, and I continue to be, when I think about it, a little nervous about this, and I don't see a better interpretation. Stay tuned, but for now, as of today, the ban is in effect. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.